Right, so welcome everybody to turning AI tech into valuable intellectual property assets. This is the first time we've taken part in Leeds Digital Festival and we're very excited to be here. I'll now hand you over to Virginia, Driver and Tom Woodhouse, European patent attorneys at Page White and Farrer.
Hello everybody, thanks Steph. So Steph's already given us a brief intro. I'm Virginia Driver, I'm a European patent attorney from Page White and Farrer, which is a long-standing intellectual property firm based in London for over 100 years, and recently, happy to say, we've opened an arm in Leeds specifically to support tech in the north, and that's where our specialist skills lie. So we're delighted to be here as part of Leeds Digital Festival, talking to you about how to turn your AI tech into valuable assets. So I'm sure most of you will know that the world has changed enormously when it comes to how companies are constructed. And these are 5 of our biggest companies on the planet today. And the proportion of their assets, which are intangible assets, is ever increasing and has increased over time. And this is what we're talking about here. We're talking about the value that lies in intangible assets, such as what comes out of your head, what you create, intellectual property. Now, intellectual property isn't a fuzzy term. It breaks down into some very, very specific criteria. And this pie chart here shows you the different, broadly speaking, the different areas of intellectual property. So in the light blue, you can see there's a class of intellectual property, registered designs, trademarks, and patents, which require formal registration. And we're going to focus today largely in this sector on patents. In the dark blue section are intellectual property rights which arise from you taking active steps to keep your intellectual property to yourself, keeping it confidential under wraps. And we're going to discuss today confidential information and trade secrets from the blue section. In the pink part are what we call copying rights. Now, these are also interesting. They don't require you to keep things confidential and they don't require you to have a registration procedure, but they do come with certain limitations, and we're going to discuss those explicitly in the context of copyright. So let's start there. So copyright is our main, what we call copying right, and it's called that because it requires copying. Now, what that means is that you have to demonstrate that somebody has had access to your work and has actually reproduced it. So somebody can't infringe your copyright if they never saw what you did in the first place. Now, because we're focusing here on AI and software, the work that we're concerned with is code, lines of code, explicitly lines of code and programs. And copyright is restricted to protecting those explicit lines of code or explicit bits of program. It does not protect the underlying idea. And so if somebody takes your overall concept and reproduces it in their own code without having seen your code and without having accessed your code, then they haven't infringed your copyright. And this is one of the main limitations on copyright as a right on which to rely. Confidential information is something which crops up a lot in considering software. People tend to use the term trade secret, and trade secret is a special class of confidential information. Now, confidential information certainly has its place in the realms of software, which is going to be completely locked down. But it does require certain active steps. You can't decide after the fact that something that somebody else has done was a trade secret or did attract confidential information. So it requires an active duty of confidence. You as the owner or you as a company have to take active steps to lock down what you regard as confidential information. The status of that is lost when the knowledge enters the public domain. So even if something started as confidential information in your journey as a company, by the time you have put more and more of your product, your services out there, some of that information may have leaked, become public, and therefore it is no longer confidential and no longer attracts this right. And Tom's going to talk to you later about how important that is when trying to secure the value of your intellectual property over time. Furthermore, it doesn't protect against somebody who independently derives the same thing. So even though you have come up with this concept, idea, code, whatever it is you're protecting by way of confidence, if somebody else independently comes up with it, that they also have a right of confidential information, which may be in conflict with yours, but there's nothing you can do about it. Furthermore, it doesn't stop someone else from patenting the same idea. Even if you had the idea first and you kept it confidential, if somebody else has the idea independently and you've still kept it confidential, they can then protect the idea by way of a patent if it's patentable. So, patents, and that's going to be one of the main focuses of our talk today, because patents are underused by many companies, particularly startup and scale-up companies. They're widely used by big companies, and I can assure you that a heavy percentage of the intangible assets that you saw on that first slide will be patents owned by large companies. Patents are a true monopoly right. If you get the grant of a patent, that protects you against anybody else doing anything which falls within the scope of your patent, whether they saw your idea or whether they independently conceived it. Furthermore, a patent right is not restricted to the individual expression. It's not restricted to your lines of code or to specific pieces of confidential information. It can protect broader concepts. And we're going to go into how some of those broader concepts might be framed and what they might relate to in the context of AI and software in just a moment. Patents can last for up to 20 years. They often don't last that long, simply because they're not needed. A patent doesn't automatically last for 20 years. Patent owners have to renew their right each year. And very typically in a fast-moving tech sector, a patent which has been granted may actually only be of use for 3 to 5 years. After that, it simply becomes redundant. So you should be aware that a patent isn't automatically standing in everybody else's way for 20 years when it's no longer pertinent. It's also relevant to point out that a common misconception with patents is that if you have one, you have to use it and you have to stop other people using your innovation or building on your innovation. And that's absolutely not the case. So patents are in your control. If you have a patent, you can decide who uses it or who doesn't. So you can expressly grant the use of your invention to people who you would like to use it and who are using it for the purposes that you think are good. You can expressly deny permission if you think that people are putting it to purposes with which you don't agree. Now, a patent is granted normally after a process of about 3 to 4 years, let's say. In that time, it's a patent application. Now, this is what this term pat pending designates. All of you have heard pat pending. A lot of you have seen pat pending. Pat pending is an indication that you have submitted an application for a patent. The proper way to use pat pending is to associate it with the official number, which is why I put NO on that slide there, which is the number that's given to you when you file a patent application. So it's a clear indication that a patent has been applied for, and this can be an effective deterrent to third parties who might be thinking about jumping in on your market space or using your AI concept or your AI application. Just having that deterrent can make somebody else think twice and at least engage in a conversation with you. So how do you get a patent? What can you patent? Can you patent anything? Well, no, as you might expect, there are restrictions on this very powerful right. You can protect new and inventive patentable subject matter. And none of these words have a layman's meaning. They have legal meanings. So new is a black and white criteria, the first hurdle you have to jump over in order to get a patent. So what does new mean? It means it must not have been made available to the public. And that means it mustn't have been disclosed in any way outside your own company without a duty of confidence. And many of you will have heard of NDAs, non-disclosure agreements. And the reason that these are used so often is because they do imply a duty of confidence in some limited circumstances. Now's not the time to go into the limitations of non-disclosure agreements, but if any of you are thinking about, well, an NDA is fine, please just make a note to maybe ask us or contact us about whether it is or not. Tom's going to talk about what's actually new in real life in a case study, which is quite interesting in terms of the limitations on your own ideas becoming not new by your own actions. So just kind of make a mental flag to remember what I said when you're listening to Tom later. So what does inventive mean? Well, inventive is a definition which is applied differently in different countries around the world. Patent offices all have their own slightly subtly different view about what we mean by inventive. And so this short phrase here is an attempt to sort of encompass geographical distribution and historical distribution about what the patent offices have regarded over time as inventive. And it's something that's not obvious to someone reasonably skilled in the art. And you're probably thinking, well, that actually doesn't get me much further forward because I don't know what obvious is and I don't know who's reasonably skilled in the art. And so we will look at a couple of these things as well in more depth. Now, before we have a look at that, what can't you patent? And there are some specific exclusions about things which definitely are not categorized as inventions. So they don't even hit the patentable hurdle in my earlier definition. You can't patent a mathematical method. You can't patent a program for a computer. And you can't patent presentation of information. So you're probably all sitting there thinking, well, this was a waste of time. I'll just go home now because AI software is either maths or a program for a computer, or it's something showing on a user interface, so I'm sunk. Well, no, you're not. And the reason you're not is because of two little words that got put into the law when this law was crafted. And this is, you can't protect these things as such. And the law explicitly says that, only to the extent that a patent relates to that thing as such. And what that as such means is that you can protect all of these things, provided that they are in a technical context. And a hefty proportion of software is used in a technical context. And there are thousands of patents granted for computer programs and thousands of patents granted for mathematical methods and AI models, just because they do not relate to that thing as such. And we're really going to drill down on this because it's really important for you to understand where your opportunities for patent protection might lie. So the core understanding in what can I protect is you can protect something if it solves a technical problem, a product, piece of code, process, a method of doing something, could be mathematical, could be an algorithm, a system, computer system, which solves a technical problem. So this can be software, as long as the software is performing a non-abstract function or solving a technical problem. In those cases, it's not software as such, and you can go into the patent procedure. So Tom's now going to pick up that theme and talk explicitly about AI and machine learning.
Thanks, Virginia. So looking at this in the context of AI and ML, can you protect AI and ML? After what Virginia said, you won't be surprised that the answer is yes. So if we look at the current guidance issued by the European Patent Office, that generally regards developments around models, etc., as mathematical methods. So to the extent it's a mathematical method as such, you can't protect it. But to specific cases where you are into the realms of technical innovation that you can protect with a patent are technical applications of models, as well as technical implementations. And actually that extends more generally to not just the models, but going back to what Virginia was saying about novelty and non-obviousness. You might be using generic off-the-shelf open source models, and the novelty in your system is in the training, or even in where you actually collect the data, generate the training set, etc., in the data processing side. And again, providing that the model you're using in that case is either fulfilling this requirement for a technical application or a technical implementation, then any of those things can result in a patentable invention. So what do we mean by technical applications? So there's been a kind of body of case law that's developed and actually predates most of the kind of the latest wave of machine learning activity by some decades even. But the patent offices generally have this idea of recognizing that there is a big difference between if you're saying that your invention is just some piece of software that processes arbitrary numbers versus some actual technical application where those numbers mean something, and that's tied to then the operation of what the computer's doing. You're now out of the realm of abstract software mathematical methods as such and into the realms of technical application. So examples could be when you're using models, for instance, to do medical things. So these kind of smart technology where you can train models to then be able to identify irregular heartbeats, for instance, is one example that's called out as a technical application of a neural network or some otherwise abstract mathematical model. Similarly, processing digital images, videos, audio, speech, essentially anything that is taking kind of low-level data and looking at patterns in it that have some kind of concrete meaning in the physical world, even if by physical world we mean an image displayed on a computer screen or some audio output from a computer or a speech recognition output that's derived from speech. That takes you into the realms of technical application. So if you're doing things in those kind of areas, then yes, you're over this first hurdle of is it inherently patentable. Other areas, cybersecurity, spoofing detection, user authentication. Again, your models are not just processing arbitrary data, they're doing something useful that's tied back to the real world, and that's giving you a technical application. Another area where particularly you're seeing a lot of stuff in autonomous driving, autonomous robotic planners, and actually simulation systems for doing this are all recognized area of technical applications of things that would otherwise be generic mathematical methods or software. Now, a technical implementation of a mathematical method is something slightly different. So if you were sort of thinking about that last slide and thinking, well, okay, but what if I've actually come up with a particular, new form of machine learning model that gives you benefits in all sorts of applications. So it's, the benefits aren't tied to a particular application. You could use this model for image recognition, text processing, anything, and the benefits it gives you, whether that's improved performance, ability to perform on less training data, are kind of generally applicable. You might think, well, that's even better than a technical application. Surely I can protect that. Now, it's a little bit tricky actually at the moment with the state of the law as to whether you can do that. It's probably something, particularly in the European Patent Office, that at the moment the current guidance is that you can't, but I think that's an open question for the future. That said, if you have a technical implementation of a model like that, or indeed a known model, but the technical implementation is new, that is an area where you can potentially protect the model independently of its application. So an example might be if you're trying to implement your new model or an existing model in a distributed computer system, and you've got sort of nodes in the model, and you need some way of efficiently getting messages back and forth between the nodes, or somehow scheduling that kind of thing to allow it to operate robustly or efficiently in a distributed system, say, you're now into the realms of a technical implementation. So you can protect that implementation without having to limit your scope of protection to a specific application like image processing, etc. And one particularly hot topic at the moment is around model compression, edge computing, embedded devices. So these sort of, like, you know, if you've got a large neural network model that can operate very well in a system where it's got plenty of memory and computing resources to allow it to do it, getting that model onto an embedded device and allowing it to run in a power efficient way or with limited storage, whatever, that again is potentially an area where you're into the technical implementation of models and into the realms of patentability. And actually, you know, I've talked about that there. Actually, potentially the technical implementation could be in the software side. So as an example I'll come on to in a bit is looking around the law that's developed around APIs. So actually, if you're working within a particular software architecture and doing your models within that, you're also potentially in the realms of technical implementation. So these are a few other examples of where you might be into the realms of technical applications, technical implementations. That last one in particular, software that results in a better computer, that sort of sounds like quite a vague, fuzzy term to be using, but actually that's more or less the terminology that has evolved in UK case law, and that the courts have been using as a way to sort of try and articulate some of the pointers that indicate when you might be outside of software mathematical methods as such and into patentable inventions. And AI is an interesting one because actually potentially AI gives you a layer of kind of underlying functionality that then allows you to do other things on top of that through training and data selection. So particularly if you're into the realms of maybe APIs and frameworks that allow you to develop AI, that's an area where, again, actually that's at the implementation level and is not just software as such. Actually, I'll go to APIs because that follows naturally. So HTC and Apple was one of the big tech litigations from a few years ago now. And this was looking at the question of APIs. So this earlier case law in the UK around the idea that if you can make your computer better in the sense of performing better as a computer that can run other applications or whatever, the courts don't really care too much and have been quite pragmatic about recognizing that whether that difference comes from a kind of new hardware implementation of the computer, which there's no question that would be a fall in the realms of patentable invention, actually those similar benefits that come from software innovation are equally patentable. And you saw here the Court of Appeal in the UK in, I think, 2013. This particular case related to the multi-touch API interface. And the courts were pretty pragmatic in recognizing that this made it an improved device in the sense of being easier for programmers to use. So if you think within a sort of, you know, a startup scale-up company, actually as you're building a viable product, even if the kind of API work you're doing internally is kind of, you will inherently be doing this kind of work, that actually a chunk of it will be considered inherently patentable because you're making your system easier for your own programmers to use. Now, if you're, for instance, in another situation looking ahead where you might start opening up this API to customers, for instance, having a patent around your API then gives you potentially a very valuable piece of IP, because for anyone looking at your company, it's sort of, it reads directly onto the piece that is visible to your customers and people like potential investors. So you start to see when you have that direct mapping between your IP protection and your actual product, that's where you can really add value in having a targeted patent portfolio. another example of that is user interfaces. So in terms of patentability, one of the other restrictions that we didn't go into on that slide, but you might have spotted it, was a restriction on presentation of information as such. So to the extent you're merely presenting information to a user, you're probably excluded from patentability under those provisions. But as soon as you have an interactive mechanism around enabling user input, that could be entering text, making a selection, submitting a command, these are interactive elements of a UI protecting its functionality, relating to its functionality, that are protectable. And particularly in the realm of apps where you have problems around constrained display area, gestures, multi-touch, going back to this need to solve a technical problem, these are all areas where a technical problem can arise in the context of UI design. And the important thing to think about here, when we're talking about copyright or design rights on a user interface, we're only talking in that context about the visual appearance of the UI. Whereas when we're into the realms of what might be patentable, we're talking about the actual functions the UI performs, the actual functionality at the UI layer. And again, that potentially gives you broader protection, because whereas you might be able to rely on copyright or design right to stop someone else from copying the appearance of your UI, it wouldn't stop them from taking the same functions and redoing them with their own code and with a different appearance. But that's where a patent potentially can. Data structures are another really interesting area that have almost crept up as a kind of another category of subject matter independently from computer programs. So the patent offices, well, the language here around functional data is terminology that's specifically arisen in the context of European case law. But you see similar things throughout the world, which is that actually if your data is allowing, and particularly if the structure of your data is allowing a computer to perform better on that data, so there is some tangible benefit tied to the way you're structuring that data, that in itself could give rise to that could be something that's patentable as well, because that structure inherently solves the technical problem in allowing the computer to manipulate it more effectively. And this is particularly relevant in the context of machine learning, where, and especially when you're looking at the kind of neural net type architectures, where actually a lot of the way that you are configuring your networks to do certain things is in how you structure the inputs and the outputs and the features that then allow you to train it or extract features in a meaningful way. So we've touched a little bit on this notion of technical problem, but I'm going to hand back to Virginia at this point to talk you through that in a little bit more detail.
Thanks, Tom. Before I do that, I just wanted to note we should have some time for Q&A at the end of this session. But if in the meantime you want to post a question in the Q&A box, which you should have, or in the chat box, please feel free to do so. And we'll either pick it up as we go, or we'll make sure that we deal with it. Because sometimes if you're listening to something, you know, it might prompt a question then, and then in another 20 minutes, you've sort of forgotten what you wanted to ask. So please feel free to pop in your questions. So I'm coming back to the criteria that I mentioned before Tom told us about technicality and what as such meant. And that is, the solution must be non-obvious. So what do we mean by this? Well, we mean that it has to be a non-obvious solution to a technical problem. And the way that the European Patent Office handles this, although it's not universal throughout all patent offices, in fact, the approach is becoming somewhat aligned, which is, have you defined a technical problem? Do you have a technical effect, which is claimed in your patent? And by technical effect, this is exactly what Tom has been talking to you about. So do these features in your invention fit into any of the categories that Tom has just discussed? And if they do, then you can sort of work backwards and think, well, if I've got a technical effect, then I have to just see what technical problem it might have been solving. And then you make an assessment as to whether or not that was obvious. And when I say you make an assessment, I don't mean you make an assessment, actually. I mean an assessment is made, because obviousness is not a layman's proposition. It's a legal test with, as I explained, a lot of historical and geographical distribution to it. So the first thing you have to consider, and this is really from a legal perspective, is it's obvious to who? And the law says it's obvious to a person of ordinary skill in the art. And probably the biggest takeaway is that most entrepreneurs, CTOs, founders, inventors are not people of ordinary skill in the art. You are people of exceptional skill in the art. So you're already ill qualified to judge the obviousness of your invention or your peers' inventions. This person is a hypothetical person, this person of ordinary skill in the art. And you can see how hypothetical he is, because he's tasked with solving the technical problem. It's assumed he knows about all of the prior art, and certainly the closest prior art. And prior art's jargon there, it just means what was published before, you know, you made your invention, but without hindsight of your invention. So an entire hypothetical framework is set up that patent attorneys and patent offices have to know and understand, so that we can make reasoned assessments based on our knowledge and experience of what's obvious in any particular case, and who the person of ordinary skill might be in a particular case. But just to remind you, it's not you. Now, obviousness itself, given that you're not the person of ordinary skill, you're already cleverer and better informed with a tighter context. Obviousness is not a layman's proposition either. Now, I'm just going to go into a couple of cases in the UK courts, which I think are very instructive on how obviousness might be considered. Tom touched on the possibility of taking a known piece of code or known model and using it in a different application. And this case of Dyson versus Hoover back in 2002 was a very interesting case. Now, until then, all vacuum cleaners had used bags of some kind or another. What Dyson did was he took well-known cyclone technology, and it was not disputed that it was well-known cyclone technology, but he decided to use it in a vacuum cleaner. And it was decided that the prejudice against that was so strong, the prejudice in the industry to use bags was so strong, that it was not obvious to use well-known cyclone technology in that context. And so his patents were upheld. In Haberman versus Jackal, an equally, if you like, kind of trite case, but it's instructive, was adding a slit valve to the drinking spout of a child's sippy cup to prevent spillage. Now, you might say, well, that's obvious to anyone, but actually spillage from children's sippy cups, all you parents out there, you'll know that was a problem. And putting this slit in solved that problem, and nobody else had done it before, and no one had thought of it. So it really couldn't have been obvious, and the court decided it wasn't. So it's really worth bearing in mind that this whole arena of what's obvious and what isn't is something for you to discuss with your patent advisor, and not for something for you to preempt and decide, oh, well, my invention is really obvious, so I'm not even going to talk about it to an advisor. And in the field of software, there's some interesting specific examples of things which you might think are very close to the line. And actually, I can tell you how close to the line they were, because we had to do some considerable argument and debate with the patent offices about the technicality of these and the non-obviousness of them. So a patent was granted for an interface which took feedback from a user about certain text outcomes that had been developed by a model, and decided they were to be discarded, and that information was used in the next round of predictive suggestions from the model. And it was decided that the combination of the back-end model and its predictive suggestions and the modification of those suggestions, and the fact that the user interface could be interacted with by the user, and you'll recall that from Tom's explanation, put together, that amounted to something that was technical and non-obvious, because in fact the prior art didn't permit that functionality at the user interface. A medical billing classification scheme was also allowed, where the confidence rating given by a model was applied to the messages, and it said you either route the message this way to a clinician or you route it another way, depending on how confident the model was about that classification being correct. So again, that's an interesting case right on the border of what's technical and what's obvious. So another example of patentable inventions in the software field, a video communication app with gesture-controlled video obfuscation. So that allowed you to see a bit of who you were talking to, but not all of them until they wanted. So kind of an interesting social media type thing. A data structure for implementing game physics in a mobile gaming app. And the technical piece here was actually the setup of the data structure itself and how it controlled rendering of the game elements on the user interface. And embedding a payment token within a digital identity verification message. We didn't actually call out explicitly on the earlier slide that business methods are also excluded from patentability, but only as such. So although this payment token was for financial purposes, undoubtedly, because it was embedded in a technical context, you can get a patent for it. So I think at this point, I'm going to hand back to Tom to just talk about a specific case study where some of these elements are brought together.
Thanks, Virginia. So I'm going to talk now, I mean, this is a hypothetical case study, I'll say up front. It's kind of an extreme situation, but it's based on things that have happened to various startups and scale-ups that we've had contact with and who have engaged us over the years, just as a little bit really of a warning about over-reliance on the notion of confidential information or trade secrets, as is often used, or at least relying on them without fully understanding what they are and what their limits are. So as Virginia said when she was discussing this earlier, there's certainly a very important place for the kind of confidential information and the way that you lock down your confidential information in the context of a tech company. It's also very important to be aware that actually this can sometimes conflict with the other pressures that are on the company, particularly as it grows and it's beyond its first year or two. So this hypothetical startup, we've said it's a data science or AI specialist with expertise in a specific data science problem. And it's a technical problem, let's say, and so you're into the realms of technical application. And it's not an uncommon business model for startups, is that actually, in terms of looking for gaps in the market, if you can develop real expertise on a niche problem, that can really give you a leading edge even over bigger potential competitors in your early years. And this startup is someone who provides software and support and software services to their customers who are larger companies, which again is not an uncommon business model. So you might have big companies who have lots of data and a startup who has really cracked a particular specific problem, say, but a really valuable one, to get the insights into that data that really give it its value to its customers. And it can be a very successful business model and one that you see startups, doing really well with. Now, if we look at their kind of hypothetical pipeline, we can consider that they've definitely done something innovative in the back end. So whatever that is, I mean, as we talked earlier, this could be any bit in this pipeline. A lot of this stuff might be known, but it could be some really key thing they've cracked in the training or the optimization or somehow that has really allowed them to sort of crack this problem that other people haven't been able to so far and really unlock the insights and the value in the data they're processing. At the other side of this pipeline is their user interface. So as part of all of this, they've developed over maybe several product iterations over a number of years, the actual UI features for how you then make the output of these analytics AI engines accessible. which again is, and this is the API or the user interface, say, that's open to their customers. And it's what allows the customers to really make full use of the stuff that the startup is doing. Now, the full details of what's going on in the back end, let's say, are not derivable from the user interface. So the startup then has this notion that it's relying on trade secrets to protect the core stuff in the back end and the analytics engine. And initially, it's probably a very successful model. So as I talked about, the first mover advantage from finding a gap in the market and solving the problem there does give them an edge for a year or two. But the issue you have in this particular circumstance is that the startups' customers are also big companies with their own engineers and their own expertise. And after a few years, let's say 1 or 2 years of working this startup, the CTO of one of their biggest customers decides we don't really need to be paying money out to this startup. We want to take this stuff in-house and save some money. So what can the startup do? Well, if we trace back to the very early days of this company, this startup, who has some notion that their tech is proprietary, that is true in the early days. So if it's just 1 or 2 people with a lot of confidential ideas that they're not sharing with anyone, actually, yes, you've got your own confidential ideas. You're ahead of other people. They are confidential. They're not in the public domain. You do have the protections afforded by confidential information. In practice, actually, it boils down just more of the fact that no one else knows what you're doing because you haven't told them yet. But the issue with this is that starts to get chipped away at quite quickly. So even those kind of early discussions with potential investors, pitching, informal chats, if we're thinking of this kind of dark blue section in the middle as the stuff that is outside of the public domain, think back to what Virginia was talking about earlier about the requirements for patentability. Novelty means that the idea hasn't entered the public domain, and you can only protect something to the extent it's new in that sense. So back on that earlier slide, your options for protecting your own tech were greater than they are now, because through even these channels like early discussions with potential investors, pitching, informal chats even, those are not under a legal obligation of confidence. They are leaking out into the public domain. And not only have you lost the legal protections of confidential information, you're also chipping away at the possibility for getting patent protection over those ideas. Now, over time, as you start to release products, you release your first product in your user interface that goes out to your customers, that's now in the public domain. So we talked earlier about the fact that if you have new user interface features that are solving some technical problem, you can protect that, and you can protect it at the level of the functionality, not just the appearance. But if you've released your product and now your UI is in the public domain, and you can now see what those features are from the user interface, and the test there is, could this hypothetical skilled person take your interface and build their own version? And the answer might be yes. In fact, it probably is yes for the kind of broad functionality that you actually might want to protect in a patent. So going back to that slide, thinking back to the slide with their pipeline, that whole area of innovation around the user interface, the ability to protect that has now gone out of the window with the first product release. And as that user interface is refined over time and more releases happen and it gets more sophisticated, that again, with every release, you're losing the opportunity to now protect those great features that enabled you to sell this and that made your product a good product for your customers. Similarly, as you start to exhibit at tech events, new websites, engineers like to talk to each other about this stuff. Engineers will, when they get on the topic of talking about their tech, will tend to quickly forget who it is they're talking about on the other side of the table. New material can end up in the website, marketing teams develop, they're looking for ways to sell the product. Actually, your engineers just themselves are looking to sell this product. So increasingly, you're not just going to be able to sell the fact that you have this magic black box solution. there's a lot of magic black box solutions out there. You're going to have to be telling your customers what your tech is doing, particularly if they're tech savvy customers, in order to effectively market it. And if you're not doing that with proper consideration to the effect it's having on the kind of deterioration of your kind of IP assets and the fact that you're now losing confidentiality and you're not replacing it with anything else, then you're potentially really starting to lose some of the value in those intangible assets that you might have had in the early days. Now, this is another one that we see quite a lot. So even if you're in this realms of you know that a lot of information about your product has got out there, in the middle there, you might still have this notion of, well, we know that we're telling people certain things, but actually we've got this core piece in the middle, our core algorithms. They're the key to it, actually. You know, the other stuff is a nice to have, but if other people don't have this, we're still reasonably secure, and we're just going to keep these as a confidential trade secret. In principle, that's a perfectly viable strategy for securing your IP assets using the legal provisions of confidential information. But it doesn't just happen automatically. As Virginia said, it's not the fact that you think this is key to your business somehow magically makes it a trade secret or confidential information. You have to be taking those active steps to maintain confidentiality. And this is really critical as the business grows and more channels for information leakage come out. So this particular startup has a notion, at least in their own minds, of what their core IP trade secrets are. In fact, they have 5 different notions from 5 different senior people within the company. As it transpires that actually, with their customers, in order to support their customers and provide a good service to them, they've been drip feeding this key information, or at least elements of it, to those customers over a number of years. And there's no, in this case, it might be that you don't have any kind of formal obligations of confidence, or it's just happening any one conversation. It's not really possible to pin on it that that's put a key piece into the public domain. But it's enough for those few years later for that customer to now say, well, I think our department, thank you very much, we've learned a lot from working with you, enough to now go at it on our own. And if you're scrambling at that point to think, well, no, they can't do that because that's my core IP, actually, maybe it isn't, because if you haven't maintained that duty of confidence and you haven't been filing patent applications in order to secure it otherwise, your customer is then free to do that and take that information and stuff they've learned from you and go at it alone. So in this case, let's say that the customer has learned enough from this drip feeding of information over the years to build their own serviceable backend. It's broadly similar to what the startup does. It's maybe not as good, but when a CTO is sort of looking on the balance of things, there's, firstly, is he going to recognize that it's not as good? And secondly, is he going to care if it's a potential for saving quite a lot of money? So they build their own serviceable backend, and they also copy your interface functionality. They don't copy your visual appearance of your interface. They don't copy any code, so there's no infringement. Now you might be thinking, well, actually we were talking to that under those customers, but we had NDAs in place, so they're not free to do this. So actually that is still our core IP. We can protect that. They've breached their duty of confidence by doing that, which is a possibility. But at the same time, when you dig a bit deeper, it turns out that actually a lot more of this core IP trade secrets has leaked out into the public domain than anyone thought. And these are all real examples of things that have happened to startup companies. So a PhD student who interned for 6 months, turns out they've included key details of the back end as context in their PhD thesis. And this has been authorized within the company because it didn't really occur to anyone that this would matter, because this isn't the audience, this isn't their customers it's going to, it's a completely different world that this is being talked about, it's academia. But no, it's in the public domain, and to the extent you had any NDAs, as Virginia said, an NDA is only valid if the thing is still confidential. So to the extent these conversations were under an NDA, they're now void, because that information's in the public domain. Similarly, it turns out your marketing team have been pitching core ideas with no NDA. You're not even sure where they've got hold of them, but they have. The other is that you might have disclosed it to 50 different customers, all under separate NDAs. And that's a circumstance where a court looking at that is probably going to say, well, you know, that NDA isn't really worth the paper it's written on, because if you look at the actual substantive question of have you taken those steps to maintain that duty of confidence and keep it out of the public domain, the answer is no, just because of the sheer number of people you've disclosed it to, those NDAs are not effective. The other is that a competitor has independently derived it and they've put it in the public domain. So you haven't put it in the public domain. You've been very careful to keep it secret, but now it's out there through a channel, through events that are completely outside of your control. You've still lost any protection that confidential information might have afforded you because they were free to derive it independently and do that. Worse, it gets put into the public domain when their patent publishes, because it turns out they've actually patented it. And then you're into the realms of now someone else has a patent, and a valid patent. That patent's valid if you didn't put it into the public domain, because the competitor's patent now fulfills that requirement of novelty. So now you're into the situation where someone else has patented what you saw as your tech. So if you think about the effect this is having on the company's intangible assets, yes, you've still got the copyright in your software, but that's potentially now a product that's no longer perceived as unique in the market. Now, it might be that it actually is still unique. Actually, you've still got a lot going for the company and you've still got specialist expertise, but that perception could be a real detriment to the value that is perceived to have. Similarly, you don't have trade secrets, or at least you've lost a lot of them. And because you haven't been taking steps to look at what is this information that we need to be allowing to step out of the company, what's the stuff we're going to hold back, where are we going to fill the gaps with patents, monopoly rights, you don't have that. So you don't have this coming up to sort of fill the gap from the inevitable leaking of information as your company grows. And that leaves you with reduced leverage in negotiations when the customer decides they want to take it in-house. So when they say we want to take it in-house, you're essentially down to sort of trying to persuade them that they still need you, but legally you can't stop them from doing that. And if it wasn't clear already, you might then ask the question, well, I can still patent it, can't I, in that situation? And of course, the answer to that, if you've been paying attention, is no, because to the extent that information has entered the public domain, either through your own actions or through independent third parties doing it independently, you can no longer patent that because it's in the public domain and those ideas are no longer new. And at this point, I'll hand back to Virginia to consider how they might go some way to rectifying that situation through IP strategy.
Yes, thanks, Tom. So I'm here to do away with all of those ills that Tom has been talking about and to turn that downwards curve into an upwards curve with really some fairly simple information. So in the context that this particular startup did have a patentable idea, and I think it's clear from the earlier discussions that we had, is a very high chance that he did. If he'd applied for patent protection right in Tom's early slide, where his core methodology was still large before it got broken up and distributed into the public domain, then they could have had a patent application pending through all of that. And then at some point, probably 2 to 3 years in, an actual patent granted. And this could have had a significant effect. So when they went in to talk to their customer who now wanted to take their invention and just use it in-house, you could have a proper discussion. You've leveled the playing field with that customer, because you can now say to them, okay, you can take it in-house, but you owe us something, right? Because we taught you that and we have a patent on that. And you might want to sell them the patent or license the patent, or you might want to say, okay, that's fine, you can have all the patent rights because actually take it in-house, but give us this other piece of work that we're working on. You know, it just gives you a piece to play with in the negotiations with that customer and doesn't leave you completely defenseless. The other advantage of having a patent application or kind of patent pending early in the day we use this phrase kind of advertise and defend your innovation. You know, it's like a badge. It's like, this was innovative. We're not just saying there's something clever at the back end. We've enshrined it and crystallized it in a patent application, which hopefully will become a patent. Furthermore, a really important piece of information for you is that you do maintain that first mover advantage, because the patent application itself stays secret for 18 months after you file it. So although most of you will be aware that by patenting something, you give everything away, I mean, there's some elements of truth to that, which we haven't dug down into, a bit too esoteric for this general talk, but none of that happens for 18 months. So your first mover advantage is good for 18 months. Nobody knows what's in your patent application except you. So it allows you to crystallize that IP asset early, and the value of that IP asset then moves with the value of the company. So you might have more than one patent. You might make a subsequent innovation and get a second or third patent. And so your value, your intangible asset value, goes up rather than down. And at that level, it is actually quite straightforward. It's a choice that you're making as a founder or CTO or CEO in your company as to whether to leverage your IP effectively, or acknowledge that actually, for whatever reason, you're content for your IP to sort of diminish, and you'll use other factors to sustain your company. And we're certainly not saying there aren't other factors to sustain your company. We're talking about IP here. So just looking at this is just a quick diagram of some work that was published by the government, which had done a study of the importance of intangible assets in the life of a company. And everything that we've talked about is sort of almost to the left of this time curve. You see early stage growth, maturity. Everything that we've been discussing with you has been kind of right in the foothills of early stage. And then what the government did was looked at different reasons why companies might want IP or be able to use IP to their advantage. The purple boxes here are things that an early stage company might want to do. And then if you see on the next slide, the orange boxes as you scale up. And then for established companies is the blue. And we don't have time to go into this in detail, but the slides will be available to you and the recording will be available to you. And I would encourage you to study the various ways in which you can leverage these patents that you might get to help sustain and increase your intangible asset value. So that's really all from us now. So I had an interesting chat just very recently, actually, and what he said to me really hit home, and so I'm sharing it. He said we knew we needed to protect our innovation, but we just didn't know where to start. We didn't know how. And you've told us, you've given us peace of mind. You've taken that weight off our shoulders. And that's what we're here to do. And we haven't explained in this talk anything about the process, anything about what you need to do, anything about what we can do for you. So we would just really encourage you to, if you think any of this applies to you, just give us a call by email, phone, and we can just have an initial chat with you and see if we can help you. I see in the chat a couple of things. There aren't any questions there, I don't think. Are there any questions from anyone? Just giving a bit of time in case people want to furiously type. No, I'll just hand back to Steph then to close this down. Thanks, Steph. Don't to unmute yourself.
Am I unmuted now?
You are.
Hopefully I'm jolly good. Well, thank you very much for joining us, everybody. It's been a pleasure to attend this event. When I sent out the webinar invitations, the actual links to the webinar, you've got my email address, so if there's anything you need, then just drop me an email, or you can visit us at our website, www.pagewhite.com. Thanks for joining us. And I'll end the seminar now. We're doing a recording, so I will send those out as well to the email addresses I've got. Thanks a lot, everyone.
Thank you. Bye.
Thanks, everyone.
Bye.